Imagine waking up tomorrow to find out you're being sued for everything you own. Your house, your savings, everything gone. Now imagine finding out that it could have been prevented with one simple document that costs less than your takeouts for the week. Today, I'm breaking down the top 3 legal mistakes that actually cost creators real money. Mistakes that could leave you on the hook for lawsuits, losing money with brand deals, or even putting your personal savings or your home at risk. Don't let that happen to you. Let's dive in. Hi, I'm Tyler Chow, the creator's attorney, and I've seen too many talented creators lose everything because of 3 completely avoidable legal mistakes. Just last week, I discovered one of my huge creator clients, we're talking over 100,000 subscribers, was sitting on a legal time bomb that could have destroyed their entire business overnight. What's worse, most creators don't even realize they're making these mistakes until it's too late. In the next few minutes, I'm going to show you exactly what these 3 creator killing mistakes are, and more importantly, how to fix them before they destroy everything you've built. So what is the number 1 mistake that creators make, which is so problematic? It's not having an LLC and not having insurance. I know those are 2 things, but I kind of think of them as one. Let me tell you about a story that happened just days ago. One of my big creator clients, someone you probably watch, reached out to me about a course that they were launching and that they were filming the next day. They needed a release for their participants. When I asked for their LLC name to draft a live participant release, I was met with silence. Turns out they don't have one. Even worse, they haven't paid taxes in 4 years. Here's why this is terrifying. Imagine you promote a health supplement and a brand deal. Someone in your audience buys it because you promoted it, and that person gets sick. And then they decide to sue. And the beauty and nightmare of living in America is that you can sue and be sued by anyone. They're going to come after everyone involved, the brand, the manufacturer, and yes, you, the creator who promoted the product. Without an LLC, everything you own is personally up for grabs. Your house, your savings, your investment, even your personal belongings. Let's say you own expensive art or a car. So what's the solution? If you're making more than $500 from your content on your YouTube channel through ads, sponsorships, courses, AdSense, whatever, you need an LLC. It costs about $500 to set up through my office. Think of it as buying a shield for everything you own. If you have an LLC, only your business assets can be touched. Things like equipment, your camera, your lighting, your laptop. Only the money that's in your business account can be touched during a lawsuit judgment. I usually lump having an LLC with having general liability and media insurance. As a creator, you should have both. Lots of brands and sponsorships actually require it now. So do you need media insurance? General liability usually won't cover content-related claims. Here's why creators also need media insurance. Media insurance is also called errors and omissions. It covers content-related lawsuits, defamation claims. Remember CoffeeZilla and Logan Paul? CoffeeZilla actually doesn't have defamation coverage because his broker failed him. Media insurance also covers copyright infringement claims, invasion of privacy claims, errors in your content that causes harm, and legal defense costs. Who are the creators that really need media insurance? If you're doing a lot of product reviews or you're talking about people, maybe you're a commentary channel, if you're constantly talking about someone else in a negative light, you might want to think about media insurance. Also, you might think, I don't need general liability insurance because I don't have a physical office and all of my independent contractors or employees are remote and work virtually. But realize that you still need general liability insurance even with remote operations. Here's why. If you ever have any off-site activities, if you film in public locations, if you're meeting with clients or sponsors, if you attend events or conferences, you're using rented equipment, pop-ups, shoots, temporary locations. Many brands actually require it now, and event venues won't let you have an event if you don't have it. Here's a real life example. A creator I work with thought they didn't need general liability insurance because they were fully remote until they had a sponsored event where an attendee was injured by their lighting falling on them. The venue's insurance didn't cover the injury because it was the creator's equipment. However, you might need less coverage than a creator with a physical space or office. A typical remote creator might start with $1 million per occurrence and $2 million aggregate coverage. Additional coverage for specific events and activities can be bought for every specific event that you're hosting. The key point is the premium for remote operations is often lower than for physical locations, but the protection is still crucial for business sustainability. By the way, a big PSA. Please pay your taxes. I know there are creators who aren't doing it because beyond IRS civil penalties, understand that if you have an LLC, courts may pierce the corporate veil if taxes are not paid. Why is this? When creators set up an LLC or corporation, they usually do it to protect their personal assets from business liabilities. However, courts, and especially the IRS, can pierce the corporate veil if they believe that the business structure is being used to commit fraud or avoid legal liabilities like taxes. This means that even with an LLC, creators can be held personally liable for unpaid business taxes, which usually happens during an audit. It's not common, but it does happen. I think I'm going to make this a 6-part roadmap for creators to learn how to legally protect themselves and understand all the ways to make money. So let's call this video part 1. I think part 2 will be all the ways to make money as I stated above. And part 3 will be how to get brand deals, including when and how to ask for equity, which I do for a lot of my big creator clients, and provisions to watch out for in a brand deal, like a cap on liabilities and mutual indemnity. I will list out parts 4 through 6 towards the end of the video so I don't lose the flow. Write roadmap in the comments below if that would be interesting to you and helpful, and hopefully solve some pain points and allow you to keep creating content for your YouTube channel. By the way, I'm not just another lawyer on YouTube. I am the creator's attorney, and it's my life's mission to protect creators. I left an 18-year career in Hollywood because I believe YouTube is the new Hollywood. I represent some of the biggest YouTubers in the world as their part-time general counsel and fractional CEO. I help them diversify their revenue stream so they're building on their own land, launching products, creating communities, starting newsletters, and capturing emails, which is, by the way, the most valuable thing you can own. All of this sets up creators' IP portfolio, which includes trademarks for an eventual exit through an acquisition by a private equity fund or a studio like MatPat and Veritasium. By the way, this video is for educational purposes only and not legal advice. All opinions are my own. I'm not your attorney. Just because I represent a lot of creators doesn't mean I represent you. Please reach out to an attorney for formal legal advice and guidance. The second biggest mistake I see creators make is running their business on handshakes and DMs. Let's break down the 3 areas where this becomes a nightmare because you don't have the proper contracts in place. Number 1, team agreements. This is independent contractor agreements or employee agreements. After 18 years working in Hollywood at companies like Disney, Skydance, and BuzzFeed, I can tell you every single creative relationship needs a contract stating that the work created for you is owned by you. Every Hollywood contract has clear ownership provisions. Without these, you're exposed. You need contracts that state that everything that you, the independent contractor or employee, creates for me is owned by me because it's work for hire, and the proceeds are owned by me. I've had clients where editors or partners try to hold their channels hostage, claiming, I made these videos, this editing style, I own half your channel. This actually happened to one of my big creator clients, and it took almost 6 months for us to unravel it. It was a huge nightmare. Don't let it happen to you. Number 2, what about brand deals? You need proper contracts in place that cover you when you're doing a brand deal. It freaks me out when I hear from creators of brand deals where there is no agreement. Perhaps there's just some emails, maybe there are text messages. So let me ask you, what happens if the brand doesn't pay? How do you go after them? The brand can say, I didn't agree to these terms, I didn't agree to pay you, I gave you a free gift, or they deny certain terms that you know were agreed to. And what about usage rights? Without a clear agreement, a brand can use your videos and content in perpetuity, which means forever, on their O&O, which stands for a company's owned and operated platforms, media channels that they fully control, like their websites, social media accounts, or email lists, where they can directly manage and advertise without relying on third-party platforms. I've had to go after bad actors, like brands not paying after a client of mine delivered 3 videos. This was a 6-figure deal. Thank goodness we had a signed agreement because they were still owed over $100,000. And this is with one of the world's biggest car manufacturers. I've also had to go after brands for having in perpetuity language. These were contracts signed before the creators had hired me, and I made them change the usage rights to a license for a limited time period. Do you know the Simu Liu story? He was a stock model before he became a Marvel star with his own Marvel movie. But he shot many photos for companies like State Farm and Zumba, sometimes for $120. And now these stock footage companies own his likeness and can use them in any advertising they want. Why? Because they have ownership language that states that they own these images in perpetuity. I'm surprised that Simu hasn't tried to buy them back because you can do that. But I imagine these stock footage companies are probably asking for an insane amount of money and basically holding them hostage. So the third bucket that's a problem where you don't have agreements in place are partnership disputes. This is an area that I do a lot of work in, which is exiting partners, unfortunately, who do not have agreements in place. Imagine you're 18 and you start a YouTube channel with your best friend. Maybe one is on camera and the other is the editor, or you're both on camera with a podcast. I've had both of these situations in the 5 exits that I've worked on in the past 6 months. So what happens when one person starts contributing or you disagree on the direction of the channel? What if somebody wants to leave? They no longer want to work on a YouTube channel or be a YouTuber. Without proper agreements in place, these situations become expensive legal battles. I've had to exit 5 different partnership arrangements. They get really ugly, like in a divorce. Make sure you know who has the login information for your YouTube channel. I've had situations where one partner holds the channel hostage, basically. Remember the whole Sniper Wolf situation? She got into that dilemma with her husband when they were getting a divorce. So lastly, what is the third legal mistake that creators make? Not protecting your IP. This one hurts to talk about. Recently, a creator came to me after spending years building their business. The problem? Someone else had already already trademarked their media company name. 3 years of brand building, gone in an instant. Yeah, they had to change the name of their company and start from scratch. Please don't let this happen to you. I've had clients who want their channel handle named only to find someone else had claimed it already and parked it with 3 subscribers. But did you know that if you have a federal trademark, that alone can give you legal grounds to challenge someone using the same name or a confusingly similar name as their YouTube channel? But whether or not you can force them to give it up depends on 4 key legal factors. Number 1, the likelihood of confusion. Number 2, the type of trademark rights that you have. 3, is the channel commercially active? And 4, first use in commerce. Who is using it for business? This explanation on trademarks and importance of it for creators could be its own video, and that should be part 4 of the 6-part roadmap. Please write trademark in the comments if that is the video that's most interesting to you. Make sure to subscribe here and sign up to my newsletter where I give all these tips for free to creators big and small. And I will also announce when my community opens in a few weeks. By the way, if you take anything from this video, it should be to trademark your channel name. The flood of creators is coming, you guys, and you do not want some kid to trademark your name out from under you. I've done 20 trademark applications for creators in the last 6 months. It's the most important thing to most creators, and it's a no-brainer type of protection. Here's what creators often miss with respect to their IP. They don't trademark their channel name or logo or their profile photo. They're not registering copyright for valuable content. They're not protecting their course materials, and they're not having proper IP assignments from their team. I've helped creators deal with people stealing their courses. I have a client who sells an amazing course for $3,000, and I have these websites that pop up that sell her content for $29 each. It's like a game of whack-a-mole. Every time I take down 5 websites, another 5 pops up. What I found to be really useful is go to PayPal and stop how they're getting paid, and that's usually very effective. Copyright also help creators where copycats are recreating their content or just clipping their videos, as well as ex-team members claiming ownership. So let's talk about what the rest of the video series roadmap will look like. I think number 5 needs to be, do you need a manager as a creator? I have many creators coming to ask me to review their management agreements. I've negotiated and redlined agreements with Knight, WME, Wasserman, as well as several smaller management companies. So I know what you need to watch out for in a management agreement. Make sure to watch out for a commission tail. Part 6 will be how to launch a product, community, or course so that you can hit 6 or 7 figures like most of my clients. I have some clients who make 8 figures a year with my help as their fractional COO. We're launching physical and digital products, communities, affiliate marketing is really important. I know all of this seems very doom and gloom, and you might be asking yourself, how often do creators actually get sued? Let me tell you, I do want to give you some comfort and tell you do not be scared, because it doesn't happen that often, but it does happen sometimes because I have creator clients who come to me who are either being threatened with litigation or have actually been sued. And would you like to guess what those disputes or litigations often involve? What was your guess for why creators get sued? Is it because of copyright infringement or defamation? I mean, CoffeeZilla is getting sued by Logan Paul for defamation, and he got really screwed by his broker who didn't get him proper media insurance with defamation. But actually, most lawsuits for creators involve employment issues, which, by the way, is the issue for most companies. And this is why it's so important to have employment or independent contractor agreements in place. Make sure you withhold employment taxes and have unemployment insurance, which gives your employees unemployment when they no longer work for you. And this might be evident, but please just run a clean business and be a good person. Do not mistreat your employees or independent contractors. Create a supportive and kind culture where people feel seen and valued. Do not foster bullies or abusive environments. The most common disputes and lawsuits come from claims for wrongful termination or some type of harassment like sexual harassment. The best protection is to be proactive, and that means treating your employees the way you want to be treated. Pretend you're working there. Would you want to work for you at your company? That's the type of company and culture I'm trying to create, because I will tell you, 20 years in Hollywood, I never found it. So these are the 3 things you need to do to protect yourself. Number 1, set up your LLC immediately if you're making more than $500. Have general liability and media insurance, and please pay your taxes. Number 2, get proper contracts in place for your team, partners, and brand deals. And number 3, protect and own your IP before someone steals it. Look, I know the legal stuff isn't the fun part of being a creator, but you know what's really not fun? Losing everything that you own that you've built because of these 3 simple mistakes. And you know what else is terrifying? Losing your channel to copyright strikes or being demonetized. I've helped many creators regain their channels after termination and have the monetization turned back on. And if you want to know how to not get strikes or be demonetized, then you have to watch this video here that I recently made. And make sure to sign up for my newsletter where I will be announcing my free community that will launch soon. The link will be below. I give these types of tips on how to protect yourself and how to make money in my newsletters. And remember, if you want my next video to be about all the ways creators can make money, write money in the comments below. Trust me, you don't want to miss this one. Oh, you're still here. I'm gonna give you some behind the scenes footage that I actually wasn't going to make. I had a new client come to me and something so terrible happened to him that I said, you know what, I need to go make a video about this and warn other creators. If you have multiple channels on YouTube, please make sure you have a unique email for each channel. I had a client come to me with 5 YouTube channels, a couple of them in the 100,000s, some in, you know, the 5-figure subscriber count, and a couple in the thousands. One of his channels got copyright strikes. It was terminated. But do you know what happened? All of his channels got terminated because it was under one email. And now I'm having to go to YouTube, and thankfully I know executives there who are helping me, but this is a huge problem. It's something you can avoid by having separate emails for each channel and separate emails for each AdSense account that you have. That's it for today. You want to hear something funny? The last 12 minutes of my video did not save because my camera ran out of space, and so I had to come back and re-record. This is the American dream we get to create, but man, oh man, is it hard because it's 1:11 in the morning right now. And I have to go upload and send these videos to my editor. This is Tyler Chow, the Creator's Attorney. I'll see you guys next time. Okay, bye.